Hi guys, it's Kathy. I hope you're doing well. We made it to Sunday. I have off a lot of days, like 4 days, 5 days in a row, off work. It's gonna be a good week. I got lots to do, lots to do, lots to do. Sleep today, sleep tomorrow, sleep the next day, sleep the next day, and then wonder where my week went and why I didn't get anything done. We're back in Denver, same docket. It was it was 8 hour docket maybe. So we saw early morning yesterday. I don't remember. And now we're gonna bump it up and go to the afternoon. I can't believe Monica's husband beat me. Look at this is the best I could do today. It really is. But it's fine.
Second.
That works for the people.
Your sure bond in this matter continues for arraignment January 22nd,
What's wrong with you?
2026, morning.
Get out of here.
Afternoon, I think works better for Mr. Huck's work.
1:30 p.m.
Perfect.
No.
Oh, and we said the 22nd, so sorry, right?
Yes.
Perfect, thank you.
Who else is ready?
Yeah, so the court's aware, I think Philip Gies is coming out off the 5A docket next for the in custody. That is a plea agreement, paperwork has been filed.
Your Honor, I can call a quick FTA if the court wants, or I am seeing him coming out, so I will wait.
I can do it from here. Yep.
If we could please call Mr. Philip Geis, he's number 11 on the 5A docket.
She's doing 5A. Okay. Just have to wait one moment until she can get back to her table.
Okay.
Okay.
Thank you. Yes.
Nothing's coming to me, Kelly. Is that a song?
Don Lavery.
She left, but she was gonna come back. Hi, Colleen.
This is off of 5A,
But the DA talked to her.
25 CR 5879, People versus William Geis.
Have us for the people.
And calling Kelly on behalf of Mr. Geis, who's appearing in custody.
No, dude, I'm not here yet. I'm here in a few minutes. Because I ordered butter pecan coffee today. Let's do that. Butter pecan coffee. And once I drink that a little bit, then I'll really be here.
Good afternoon, Mr. Geis.
Good afternoon.
Here for arraignment today. How would you like to proceed, Ms. Kelly?
Your Honor, we've reached a proposed disposition. Paperwork has been filed. Mr. Geis will be pleading guilty to Class 1 misdemeanor, third-degree assault with a stipulation to 2 years of domestic violence supervised probation.
What does UTC mean?
VTC, Veterans Court, sorry.
Is that correct?
Yes.
Mr. Geis, we're going to have a conversation about what your lawyer just told me. Speak right into that microphone. Start by saying your first and last name.
Philip Geis,
Are you the defendant charged in this case?
correct?
How old are you?
38,
How far have you gone in school?
college, bachelor's.
Do you read and understand the English language?
Yes,
Are you thinking clearly today?
yes,
Are you under the influence of any street drugs or alcohol?
no,
Have you consumed any
Monica, thank you for the Christmas present, PayPal. I appreciate that. Thank you, thank you. Am I for real? No way. Not until I have coffee.
Any pill, drug, or alcohol in the past 24 hours?
No.
Do you suffer from any mental or emotional condition that makes it difficult for you to understand what's happening today?
No.
Disposition, as I understand it, is you'll plead guilty to original count 2, assault in the 3rd degree. It's a class 1 misdemeanor. There's an agreement to 2 years of supervised probation through the domestic violence program there, a mental health evaluation, and any recommended treatment. I don't know how 5A normally proceeds, but reserving restitution is not a thing in Colorado. Is there a determination of restitution being made today, and the dollar amount will be determined at a later date?
With my apologies, Your Honor, for that old language in there. I have spoken to the listed victim. We are not seeking restitution. We can get that addressed today.
No restitution would be sought. Is that your understanding of the disposition, Mr. Geis?
Yes.
Is that how you want to proceed today?
Correct.
Have you had enough time to discuss this with Ms. Kelly?
Yes.
Are you satisfied with her representation?
Yes.
Count 2 says assault in the 3rd degree on or about October 14, 2025, Philip V. Geis unlawfully and knowingly or recklessly caused bodily injury to Don Wimmer in violation of the law. With respect to count 2, what is your plea? Not guilty or not guilty?
Guilty.
Are you a member of or a veteran of the United States Armed Forces?
Yes.
When did you serve?
2006, 2012.
There are resources that may be available to you through the Veterans Administration. I can give you this card if you would like, if you think that would be helpful. Would you like this card?
Sure.
Ms. Kelly, I'll ask you to share that with your client. Before I can accept your plea, I need to make sure you understand certain rights that you have and the effect of your guilty plea on those rights. You have the right to be represented by an attorney, not just today, but at any proceeding that would be held in this case, up to and including trial. If you were indigent, if you could not afford an attorney, one would be appointed for you by the court at no cost. You have the right to a speedy and public trial, which must be held within 6 months of the entry of your plea of not guilty. At trial, you'd be presumed innocent. You would not have to prove anything. The district attorney would have to prove your guilt as to all the elements of the charged offense beyond a reasonable doubt to a unanimous jury of 12. At trial, you'd have various personal rights. You'd have the right to testify. You'd have the right not to testify. You'd have the right to choose whether or not to testify. You'd have the right to present evidence and call witnesses, including asking the court to issue subpoenas for witnesses and documents. You'd have the right to confront any witnesses called by the district attorney, to cross-examine them and ask them questions. If you were convicted at trial, you'd have the right to appeal to a higher court. Do you understand all those rights?
Oh, we know.
Do you understand all of those rights?
Monica,
Yes.
Do you have any
we
questions for me
know.
about those rights?
No, sir.
Do you understand that by pleading guilty today, you give up all those rights, there will not be a trial?
Yes.
The lawyers have given me several documents. The first one is captioned. Request to plead guilty, Rule 11 advisement misdemeanor, has the initials PG along the sides of pages 1 and 2. A signature above the line for your name that looks like was signed, on behalf of you by your attorney, dated December 18, 2025. Did you ask your attorney to initial and sign this document for you?
Yes.
By initialing, and did you have the chance to ask her any questions you had about this document?
Yes.
By initialing, having her initial, sign, and date it, does that mean you read and understood what it says?
Correct.
Next document, captioned admission to a domestic violence pursuant to section 18.6, 800.3 CRS, signed on your behalf by your attorney, dated today, December 18, 2025. Did you have a chance to review this document with your attorney?
Yes, sir.
Were you able to ask her any questions you had about it?
Yes.
By signing and dating it, does that mean, or by her signing and dating it on your behalf, does that mean you read and understood what it says?
Yes.
Final document, elements, assault in the 3rd degree, class 1 misdemeanor. Signature above the line for your name, today's date. Did you review this document with your attorney?
Yes.
Did you have the chance to ask her any questions about you had about it?
Yes.
By being signed and dated, does that mean you read and understood what it says?
Yes.
Do you admit that you committed the offense listed in the elements And are you waiving the requirement of the district attorney to prove those elements beyond a reasonable doubt to a unanimous jury of 12?
Yes.
In signing all three of these documents, do you understand you're waiving any defenses you may have had to this charge?
Yes.
You're subject to certain penalties as provided by law for the Class 1 misdemeanor. You could be sentenced up to 364 days in the county jail, fine of $1,000. I understand you have an agreement to probation, but that's the maximum possible penalty for this offense. Do you understand that?
Yes.
Other than the disposition we've discussed, have any other promises been made to you to get you to plead guilty?
Yes.
What other promises have been made to you?
What other promises have I made? I've also, so with Veterans Court, I've also promised to get,
No, he's asking if anybody's made any promises
oh,
to you.
no. I apologize. I have tinnitus, so everything blends in.
That's okay. Has anyone made any other promises to you
No.
to get you to plead guilty?
Negative.
Is anyone forcing you or pressuring you into pleading guilty?
No.
Is your decision to plead guilty your own free and voluntary decision?
No.
It is not your own free and voluntary decision.
I'm sorry. It is not voluntary. It is voluntary. I apologize. Can you repeat the question?
Certainly.
Now that I can.
Is your
answer it.
decision to plead guilty your own free and voluntary decision?
Yes.
Wait,
As
wait.
to factual
Did we ask if he was on drugs and messing up his mind for this? Did we ask that yet, Judge? You might want to re-ask that one.
basis,
I stipulate, Your Honor.
do you have questions for me about your plea?
No.
Is this still what you want to do?
Yes.
I'll note the court's file reflects Rule 5 advisement. Anything further on the plea, Mr. Evans?
None on the plea, Your Honor.
On the plea, Ms. Kelly?
No, Your Honor.
I will accept your plea, make written findings that it is entered knowingly, intelligently, and voluntarily. Judgment of conviction enters on count 2, counts 1 and 3 are dismissed. How would you like to proceed with sentencing?
We'd like to proceed to immediate sentencing.
Waive PSI
Yes.
for the people?
That's fine, Your Honor.
Any issues under the VRA?
Your Honor, so the listed victim was here all morning, was hoping to be here for this setting. She had to step out to take a phone appointment. I have sent my colleagues downstairs. They have not seen her downstairs. I do have her wishes. I am in compliance to proceed.
What I'd like to do, Mr. Geis, is first I'll hear from the district attorney, then I'll hear from your lawyer. I'll give you the last word if you'd like to say anything.
Yeah, the listed victim in this case is Miss Dawn Weimer. As I stated, she was present throughout the morning. She is in favor and in support of this plea disposition. What was critical to her in moving forward with this case was the mental health treatment component. She had indicated that that has been a problem in the past and is hopeful that Mr. Geis, with appropriate treatment, will be able to get his actions under control.
Any restitution?
There is no restitution.
We'll find no pecuniary loss, order no restitution. Ms. Kelly?
Your Honor, I'm just asking the court to sentence him to the stipulated proposed probation. I agree with Ms. Chavez that I think the primary concern here is mental health. I don't think Mr. Geis disagrees with that either. When I first met with him, we talked about his mental health. He doesn't currently take medication, but he wants to. He was getting enrolled in VA services prior to his arrest, and I think the allegations in this case are very mental health related as well. We're just additionally asking the court to waive any waivable fines, fees, and costs. Mr. Geis has been unemployed for the past few years. He just got housing through the VA, and they have set him up with veterans services and benefits, and that's how he's been paying his bills. But he's been unemployed for a pretty long amount of time, and he's been in custody for the past 3 months. So we're asking the court to waive any waivable fines, fees, and costs, given especially probation, not having vouchers, et cetera, these days, just to alleviate any financial burden.
Thank you. Sir, you don't have to say anything. I'm happy to listen to whatever you'd like to tell me.
Yeah, I have severe PTSD and like I do, I'm a good member of the community. I have 2 kids, a 16-year-old and a 15-year-old that I also try to support. So if I could receive like the minimum amount of restitution, that would be amazing.
Thank you. Here now for sentencing, I will follow the agreement of the parties on count 2, third-degree assault, the class 1 misdemeanor. I will sentence you to 2 years of supervised probation through the Denver Adult Probation Department. Terms and conditions to include a mental health evaluation and any recommended treatment, standard terms and conditions otherwise. The court's file reflects the domestic violence admission. There is no fine. I will impose statutory costs and fees. The defendants mandatory protection order
We'd like to address that, Your Honor.
entered on October 22nd, 2025. What is the people's position on the mandatory protection order?
So, Your Honor, I've spoken to Ms. Weimer about that. There was some apprehension in terms of full contact, but
My coffee's here already. I just ordered it on stream with you, and it's downstairs. I'll be right back.
ultimately that is what she was requesting if she had been here today. Ms. Weimer has been in contact with Mr. Geis's Veterans Affairs, I think coordinator is probably, or case manager is probably the most appropriate term. Prior to this case coming in, they were both on a lease for veterans housing. It is my understanding from Ms. Weimer, however, that they are willing to work with her should the mandatory protection order stay in place. She is ultimately requesting full contact. The people's position is that I would be asking that we start with electronic contact in light of the sentence here, as well as the concerns to get Mr. Geis moving forward into treatment.
We're asking the court to allow for full contact. In my communications with Ms. Weimer over the past few months, she has not wanted this case to move forward. As Ms. Chavez noted, she just wants some mental health treatment for Mr. Geis. She indicated to me today she has no problems, no fear, anything about that. As far as him moving back in with her. And she said that she doesn't want him to be displaced from his veterans housing because of her. But if the MPO remains full no contact, one of them is going to have to be essentially kicked out of housing and homeless for the holidays and for the winter months. So we're asking that the court allow full contact because that is Ms. Weimer's wishes as well as Mr. Geis's wishes. And it's going to impact their housing and children as well.
And I'm sorry, if I may just note, also in speaking with Ms. Weimer, I do take Ms. Kelly's point that someone may have to move out of this particular housing, but it's my understanding from Ms. Weimer via the case manager that no one was going to essentially be left hanging, was where I had left it with Ms. Weimer this afternoon.
Is there information about alcohol use or controlled substance use that impacted this case?
I think one hand kind of feeds the other in terms of the mental health. There was, I think, some indicia noted, but if I can have a moment to confirm that.
Box number 7 is checked.
Your Honor, I think that had been, I apologize, I had been just reading a prior report. It had been, alcohol had been noted in a prior report, but not in this one. This one, the annotations in terms of observations are primarily mental health related.
Do you believe that it is appropriate for me to leave that provision in place for the safety of the victim or any witness here?
I do, Your Honor, and the basis for that being a prior incident report where substances was noted.
We have no objection, Your Honor.
To that provision remaining in effect?
Yes.
Oh, and I'm sorry, Your Honor, this is Ms. Weimer. If I may have just one moment.
Yes.
Here this is Ms. Weimer. She is present. She doesn't have anything additional to add for the court, just does renew her request. She is looking for a full contact.
What I will do, Mr. Geis, is I will ask the people to prepare an amended mandatory protection order that checks boxes 1, this crime is not governed by the Brady Handbill Act, is that right?
There are no weapons involved in this case. Mr. Geis doesn't have any to relinquish.
I'm talking about box number 4.
Yeah, no. Well, it's domestic violence, so
Yes.
yes.
So box number 4 should be checked. Box number 5 should be checked. Box number 6 should be checked. Box number 7 should be checked. Box number 8 should be checked. The no contact provision of box number 10 will be unchecked. So that should not, I'm allowing full contact, but you may not do anything that intimidates, retaliates against, molests, otherwise bothers the listed victim or any witness to this offense, but you may communicate with that person directly or indirectly. The firearms and alcohol provisions, other drug provisions remain in full force and effect. If you would please prepare that, Ms. Chavez. Mr. Geis, that will be the order of the court. You'll need to sign it. The clerk will sign it. I'll sign it. You're advised that violation of that mandatory protection order could result in additional charges for violation of a protection order. Those are misdemeanor charges. Tampering with or intimidating any witness or victim in the case could result in felony charges for tampering or intimidating a witness or a victim. Do you have any questions for me? You are ordered to report to the probation department. I don't know when you're going to be released today, no later than Friday, December 19, 2025 at close of business. Your success here is going to start by reporting to probation. If you're released before 5 o'clock today, you can go today, but you need to do it no later than tomorrow. Does he have
And-
any out-of-county holds or other?
Yes, Your Honor. He'll be transferred to Arapahoe.
V,
He said-
thank you so much. Thank you, thank you, thank you. I appreciate it. Guys, my coffee is hot. I have hot coffee. I just can't believe this is happening to me. I went down to get my coffee that I just ordered. And my son is dead asleep. He's in the living room, remember? Because the homeless person moved into his room. So he had to move to the living room. So when I go downstairs, I see him. And he's dead asleep. He worked not as long as I did yesterday, but not by much. He had like 1 less hour than me yesterday. And I already know what happened. I opened the door to get my coffee. And there's a big bag of McDonald's down there. And he's dead asleep. So here's what happened. And I know what happened. I do it all the time. He got off work and he knew, listen, I have got to eat something. I just worked. It's time. I have to eat something. I cannot make anything. I'm too tired. The kitchen is too far. Let me order something. And then he placed the order. And then he fell right to sleep. And then I woke up and got my coffee and boom, there's his McDonald's. I should just eat it. He'd never know that he ordered it. You're not late. You're fine. Thank you so much. I appreciate it. I lost my mouse. There it is.
At their January 8th, I'm hoping they're going to be able to get him added onto the docket next week. But if we could have maybe just like 72 hours after he's released, or
You expect that matter to resolve on January 8th?
then, or potentially before then.
You are ordered to report to probation in Denver within 48 hours of your release from wherever the last place you are released from. If that's here, if it's out of county, you need to make your way downtown within 2 business days, 48 hours, and check in with probation. If you don't do that, they're going to file something and we're going to find out pretty quickly we'll be in a different situation than we're in today. Do you have any questions about that?
We state 2 business days just in case it's on Friday.
Business days, yeah.
Well, if it's on Friday, 2 business days, it's gonna be Sunday. Right, if they're not
Business
open on
days is
Sunday.
Monday, Tuesday.
But it says within 48 hours.
Thank you, Your Honor. We have nothing else.
Anything else, Ms. Chavez? Before you leave, sign that or have Ms. Kelly take a look at that, sign that, and then you're on your way. Mr. McCarthy.
Your Honor, if we could please call number 62 on the docket, Ms. Tolbert, as a courtesy.
Say the number again.
62.
62 is 25 CR 5423, People versus Monet Tolbert.
Sam Hamowitz for the people.
John McCarthy is a courtesy for Ms. Tolbert, who is present to my left.
Good afternoon, Ms. Tolbert.
Good afternoon.
Here for arraignments.
And Your Honor, Ms. Federer informed me that Ms. Tolbert did apply for the public defender's office and she did not qualify. She's asking to set this matter over so that she can retain private counsel.
Is that right, Ms. Tolbert?
Yes, sir, that's right.
How much time would you like?
I would say about 20 more days. I have an appointment with my lawyer
Malta,
next
thank
week.
you so much. Thank you.
Mr.
Thank you.
Hammonds?
Your Honor, 4 to 6 weeks, no objection.
How is Thursday, January 29?
That works
Do you
perfectly.
prefer the morning or the afternoon?
The afternoon, please.
Morning can be a little bit. more
Yeah,
fun.
let's hear out morning.
Does that work for you?
That does, Your Honor. Thank you.
Continue this matter for appearance of counsel Thursday, January 29, 2026, 1:30 PM. Are you on a surety bond or a cash bond?
I'm on it, cash bond.
Your cash bond continues to that day and time.
Okay,
Anything else?
Not from the people.
If you are able to retain your lawyer, advise them of that date.
okay,
If it doesn't work for them, sometimes they can ask to move it, but otherwise plan to be back here. that day.
okay. Thank you, Your Honor.
Thank you.
And if we could next call number 10 on the docket, Mr. Davis.
Thanks, Chief.
Well, I was just thinking that, but so far I've come up with nothing. Nothing has happened. This is the afternoon of the docket. We're supposed to be seeing stuff.
10 is 25 CR
It's
4567, People
Bell.
versus Christopher Davis.
Good afternoon, Your Honor. Kim Falone on behalf of the people.
Good afternoon.
I've misplaced my shirt that says this. I'll find it. I just started packing. So I probably packed it. But I was looking for it. Because I love it. Oh no, Mr. Bill. Bill, I know you sent me some text messages, but I can't read anything that tiny until I take a few more sips of coffee. That's just how life works when you get old.
Ms. Flum.
John McCarthy on behalf of Mr. Davis, who is present on bond.
Good afternoon, Mr. Davis.
Good afternoon.
Here on arraignments.
Your Honor, we do have a proposed disposition for the court. I uploaded paperwork and elementals this morning.
Bill, if you're driving, don't answer me. You can safely ignore me. I have the content ready. Nope, I did not misplace my shirt. I misplaced my shirt. See the difference there? I have the content ready, Bill. Name the day and time. Your channel or mine. We're going to do a live stream together. If you don't want to do it on your channel or my channel, I have 17 other channels. We can use one of those. I don't care.
And it doesn't appear my colleagues uploaded the motion and dismiss. I'll do that right now, Your Honor.
Monica,
The people
Thank
are
you for
adding
the
count
cheers.
3 criminal mischief, a misdemeanor in the first degree.
The disposition is.
And he will be pleading to that, with the agreement being a stipulation to probation.
oh, I can't possibly
with,
do it Thursday. No, just kidding.
concurrent to his,
Time. 8 p.m. Is 8 p.m. good for you?
his case in.
Oh my God, no. Did you think I meant 4:30? You absolutely, I am not. No way am I asking you to get up at 4:30 in the morning. Or 5:30. Or 6:30. No. I mean at night. I mean at night. Don't worry. You don't have to wake up. You don't even have to wake up during this. Don't text and drive. 8 p.m. unless you tell me otherwise.
I believe it's, let me look up the roll of, and I believe it's Jefferson County.
It's Jefferson County, 22 CR 01018.
This agreement's of $4,617.28.
Correct.
That's all correct.
That's all correct.
Mr. Davis, we're going to have a conversation about what the lawyers just told me. Start by saying your first and last name.
Only my
Christopher
knees are
Davis.
Are you the
70.
defendant charged in this case?
Yes.
My
How old
back
are
is
you?
60.
29 years old.
How far have you gone in school?
Some college.
Do you read and understand the English language?
I do.
Are you thinking clearly today?
I am.
Are you under the influence of any street drugs or alcohol?
No, sir.
Have you consumed any pill, drug, or alcohol in the past 24 hours?
No, Your Honor.
Do you suffer from any mental or emotional condition
No.
that makes it difficult for you to understand what's happening today?
No.
The disposition, as I understand it, is you'll plead guilty to added count 3, criminal mischief. That's a class 1 misdemeanor. You'd be sentenced to 1 year of supervised probation through the Denver Adult Probation Department. You agree to pay restitution in the amount of $4,617.28. This would run concurrently or at the same time as your sentence. Has he been sentenced in Jeffco?
Yes, Your Honor.
In Jefferson County, 22 CR 1018. Is that your understanding of the disposition?
It is, Your Honor.
Is that how you want to proceed? today?
Yes, Your Honor.
Have you had enough time to discuss this with Mr. McCarthy?
Yes, Your
Are
Honor.
you satisfied with his representation?
Definitely.
Added count 3.
I'm going to print it, Your Honor. It won't allow me to e-file for some reason. I'm not sure why. Yes, I'm printing it right now, though. Are you able to e-file it?
What do you mean?
Motion to add dismiss. It's blocking me from e-filing.
Oh,
First, yeah. Your Honor, does the court have evidence that it's bound up in your filing system? It's not bound up in my filing system.
No.
Dr. something Gray? Dr. something Gray.
Did you, Mr. McCarthy, did you file the plea paperwork? Your Honor, may I approach?
Yes. Added count 3 says on August 12, 2025, Christopher J. Davis, in the course of a single criminal episode, unlawfully and knowingly damaged the real or personal property of Urban Sombrero, the aggregate damage being $1,000 or more, but less than $2,000 in violation of the law. With respect to added count 3, what is your plea, guilty or not guilty?
Guilty.
Thank you. That's weird.
Are you a member of or veteran of the United States Armed Forces?
I am not, Your Honor.
Before you can accept your plea, you need to make sure you understand
that's
certain
why he
rights
said
that you have and
Thursday.
the effect of your
I'm
guilty
still going to be
plea
here.
on those rights. You have the right to be represented by an attorney, not just today, but at any proceeding that would be held in this case, up to and including trial. If you were indigent, if you could not afford an attorney, one would be appointed for you by the court at no cost. You have the right to a speedy and public trial, which must be held within 6 months of the entry of your plea of not guilty. At trial, you'd be presumed innocent. You'd not have to prove anything. The district attorney would have to prove your guilt as to all the elements of the charged offense beyond a reasonable doubt to a unanimous jury of 12. At trial, you'd have various personal rights. You'd have the right to testify. You'd have the right not to testify. You'd have the right to choose whether or not to testify. You'd have the right to present evidence and call witnesses, including asking the court to issue subpoenas for witnesses and documents. You'd have the right to confront any witnesses called by the district attorney, to cross-examine them and ask them questions. If you were convicted at trial, you'd have the right to appeal to a higher court. Do you understand all those rights?
I do, Your Honor.
Do you understand that by pleading guilty today, you give up all those rights? There will not be a trial.
Yes, Your Honor.
The lawyers have given me several documents. First one is 4 pages long. It's captioned Request to Plead Guilty, Rule 11 Advisement Misdemeanor. The electronic initials CD along the sides of pages 1 and 2. An electronic signature above the line for your name dated today, December 18, dated 1 year from today, December 18, 2026. Are those your initials and electronic signature on that document?
Yes, Your Honor, they are.
Did you intend to sign it today and not in the future?
I did.
By initialing, signing, and dating this document, does that mean you read and understood what it says?
Yes, Your Honor.
Did you have a chance to review this document with Mr. McCarthy?
Yes.
Second document captioned elements, criminal mischief, $1,000 to $2,000, class 1 misdemeanor, electronic signature above the line for defendants, today's date, December 18, 2025. Did you have a chance to review this document with Mr. McCarthy?
Yes, Your Honor.
Were you able to ask him any questions you had about it?
Yes, Your Honor.
By signing and dating it, does that mean you read and understood what it says?
Yes.
Do you admit that you committed the offense listed in the elements, and are you waiving the requirement of the district attorney to prove those elements beyond a reasonable doubt to a unanimous jury of 12?
Yes, I am.
In signing both of these documents, do you understand you're waiving any defenses you may have had to this charge?
Yes.
You're subject to certain penalties as provided by law for the class 1 misdemeanor. You could be sentenced to up to 364 days in the county jail, fine of $1,000. I understand you have an agreement to probation and that probation would run concurrently as your Jefferson County sentence. That's the maximum you could get for this offense. Do you understand that?
Understood, yes.
Other than the disposition we've discussed, have any other promises been made to you to get you to plead guilty?
No, Your Honor.
Is anyone forcing you or pressuring you into pleading guilty?
No, Your Honor.
Is your decision to plead guilty your own free and voluntary decision
Yes.
as to factual basis?
Waive, Your Honor.
Do you have questions for me about your plea?
No.
Is this still what you want to do?
Yes.
I'll note the court's file reflects Rule 5 advisement. Anything further on the plea?
Nothing from the people, Your Honor.
On the plea? I will accept your plea, make written findings. It is entered knowingly, intelligently, and voluntarily. Judgment of conviction enters on added count 3. Counts 1 and 2 are dismissed. On sentencing, Ms. Flown, what would you like to do?
Your Honor, the people are requesting restitution, which has been filed previously in the amount of $4,617.28.
Do you waive the PSI?
We do, Your Honor.
Immediate sentencing
Correct.
for the defense? What I'd like to do, Mr. Davis, is first I'll hear from Ms. Flown, then I'll hear from your lawyer, Mr. McCarthy. I'll give you the last word if you'd like to say
Okay.
anything. Ms. Flown.
Your Honor, this was an event which involved the defendant being intoxicated in the patronage of the urban sombrero. He was asked to leave the property. He damaged a TV in the interior of the property by ripping off the wall and threw a rock through the window on the outside. At the time of the arrest, the defendant did not have any criminal convictions, but he did have an active warrant for the Jefferson County case, which was a motor vehicle theft, which he pled down to a misdemeanor. And he had some other GS and a DV case, an MU, which was taken care
Kelly,
of. So right
thank you
now,
for
he
the
just has a
cheers.
conviction for the Jefferson County misdemeanor case. The people think it is appropriate to ask for the restitution and 1 year supervised probation.
What is Urban Sombrero?
It's a restaurant / bar. They serve alcohol and food.
Thank you, Mr. McCarthy.
Your Honor, I'm asking the court to embrace this disposition, as Ms. Falone accurately stated. Mr.
Can you pull
Davis-
that microphone a little bit closer?
Sorry. Mr. Davis has very minimal criminal history. I met with him while in custody, and he immediately wanted to take responsibility to make the restaurant whole. I think he was very embarrassed by his actions that night. It was out of character for him, and he is appreciative of Ms. Falone's offer to keep a felony off of his record. I think that given the facts of the case and who Mr. Davis is, this is an appropriate resolution. I would ask, in light of the substantial restitution, that the court consider waiving any fines, fees, and costs that are waivable.
Thank you. Mr. Davis, you don't have to say anything. I'm happy to listen to whatever you'd like to tell me.
Yeah, I would just want to say, as my attorney stated, I just want to thank the court and also the DA for the opportunity to complete probation. And I believe that I'll be a great candidate and I will complete it successfully.
Thank you. Here now for sentencing, I will follow the agreement of the parties on count 3, added count 3. I'll send you to 1 year of supervised probation through the Denver Adult Probation Department. Standard terms and conditions. There is no fine. I will impose statutory costs and fees, order restitution as outlined in the restitution worksheet filed by the people on December 17, 2025 of $4,617.28. There is no additional Denver County jail time. A written protection order was entered in the county court on August 13, 2025. What is the people's position on that mandatory protection order?
Your Honor, the people do not believe it has to continue.
Move to vacate?
Yes, please.
People's motion to vacate the mandatory protection order issued August 13, 2025 is granted. There's no longer a mandatory protection order in effect in this case. There's no restrictions on your contact with the people that were involved or going to that location. Those restrictions are vacated as of now. Do you have any questions about that?
I do not, Your Honor.
Your order to report to the probation department by close of business today, you should just walk right across the street. You have a red card with the address. Your success here all starts by reporting today.
Yeah, beautiful. I'll head right over.
Do you have any questions?
I do not, Your Honor.
Is there anything else on sentencing?
Nothing from the people, Your Honor. Thank you.
Nor from defense.
Good luck, sir.
Thank you.
Mr. Gutierrez? These are 20 and 21, which are both 22 CR 495, 22 and 23, which are 22 CR 278.
Amelia Sapp on behalf of the people.
Mark Burton on behalf of Mr. Gutierrez, who appears in custody.
Good afternoon, Mr. Gutierrez. Thank you for your patience today.
You're welcome.
First, I need to apologize to the parties. I think that my order about setting this in advance of today's hearing was unclear. My intent was not to set it for competency hearing yesterday, but rather to accelerate the process that we're going to undergo today about figuring out what the next steps are. So I did not intend to suggest that we should hold the competency hearing in advance of your statutory right to request a second competency report. I was not attempting to make any comments on the legal validity or the wisdom or anything else with respect to your right to request a second report. It was just my thought that perhaps we could figure out what steps are going to happen next more quickly. But all the same, we're here today and we have a few things to talk
Judge,
about. We have the pretrial conference.
Judge, you should make a list. That's what I do when I have to do steps of something to get something done. I make a list. Sometimes my lists have lists. Like my first thing on my list is do list A and do list B. It could turn into a snowball, but you should just start with a list.
Differences in both matters, which have been combined for a single trial. We have defense request for a second evaluation that was filed on December 11, 2025. There's a motion for hearing that was filed on December 12, 2025. The people have responded, rather a motion for hearing from the people on December 12, 2025. Defense response on December 15, 2025. Mr. Burton.
Judge, well, I appreciate the court's comments that it appeared that you'd already made a determination.
No.
But as I put in my response, we're asking for a second evaluation. We've perfected it. We've done it within 14 days of the other report. And I mean, I can go through the statutes, but it's pretty much mandatory that occurs. If you want me to speak more.
Let me hear from Ms. Sapp.
Well, I disagree. I don't think that it is mandatory. I think that the statute, when we're looking at 16.8.5103, first of all, it's not within 14 days, it's within 7 days. So the statute has been amended to amend that time frame to be 14 days after the receipt of a court-ordered report. It's the people's position, and I understand what Mr. Burton is saying. However, the statute, the way that it is
So
written, it
much,
is not
Monica.
designed to
Monica, we need to make a list for that answer.
create this loophole, if you will, that we can then constantly toggle through the criminal justice system, raising competency, finding someone competent, then raising it again, firing an attorney, getting a new attorney, raising competency, which is the posture of this case. The Rodriguez case that I have cited before to Your Honor, and I believe, if I'm not mistaken, mentioned again in my request for a hearing, essentially puts a pin in this and says, at some point, the court can stop the spin and say, no, I actually have enough information to proceed. Now, I think that the court is well within its right in the statute to hold a hearing. And it would be my burden at that hearing to show that Mr. Gutierrez is competent. I would need to subpoena the doctor that did the evaluation, potentially subpoena other doctors. The reason I say this is not the first cycle of this. We have had prior findings of competency before this new round of competency has been raised. So it's the people's position that the court can make a determination, can make a finding, and can hold a hearing if the court doesn't feel like it has enough information to proceed at this point with respect to whether or not Mr. Gutierrez is competent to stand trial. If the court agrees with me and does believe it has enough information to make a finding of competency under the statute, I don't think our jury trial on January 12th is in jeopardy. If the court continues to agree with me, but yet wants to set for a hearing, I think our January 12th jury trial could be in jeopardy. Even if arguendo, we could get a hearing scheduled sometime between now and before the time of trial. And similarly, if the court disagrees with the prosecution and believes that the statute mandates that a second evaluation be ordered at Mr. Burton's request, I think also our trial date would be in jeopardy. So we should probably take it in chunks because I've already talked to the clerk and kind of looked at a couple of other dates that we could maybe put as a placeholder for a future trial. But that said, Your Honor, I do believe the court has enough information to make a determination at this point in time based on the totality of the circumstances, not just this one evaluation cycle as we're talking about. Additionally, I do believe that people are entitled to a hearing to show that Mr. Gutierrez is competent to proceed to trial.
May I respond to that, Judge?
Certainly. Before you do, I absolutely agree that he's entitled to a hearing. The question in my mind is, when does that hearing occur? Mr. Burton.
Judge, the district attorney is misreading the law completely. On 16.8.5.103, which is when you initially ask for a competency evaluation, it says the court may order a competency evaluation. At that point, the court has some discretion within the case law on the et cetera. But however, under 8.5.106, it says that the court shall order, upon request, shall order that a competency evaluator chosen by the defendant be appointed. And it goes on, and then 16.8, it's in my motion, Judge, but 16.8.5.103.4, it says the court must continue any hearing on competency until the second report is submitted. So I think that the district attorney is encouraging the court not to follow law, but that's the law. It's mandatory, and we're asking for it.
I believe that once I ordered an evaluation at the defense raising competency
That makes me happy when that
a
happens.
few weeks ago, that began a process whereby, depending on what that evaluation said, the defense has a right to ask for a second evaluation, which is where we are today.
Right.
So I agree that that is what statute provides. The question is, how does that intersect with the trial date of January 12, 2026? It is December 18, 2025. That is over 3 weeks
Yeah.
away. I don't know what
I don't think
kind of professional responsibilities the person you've identified has.
over Christmas. Yeah.
It is not a weekend, it is several weeks. My thought is to order the second evaluation, set for competency hearing, if necessary, on Friday, January 9, 2026 at 1:30 in the evening. Order the report due.
Judge, I don't think there's any way we can get a report by that time. The second evaluators are always heavily set, because there's very few of them. So I don't think that's possible.
Am I able to order it?
Sure, you can order it, but I just, I mean, you can order that the moon turn blue, but I don't know if it's going to happen.
Let me complete what my thought process is. I would order the second evaluation due January 7, 2026, set for competency hearing 1:30 Friday, January 9, 2026, not move the trial dates, see where we are on January 7.
That's fine. I have a sentencing on a large case at 1:30 on January 9th. I could maybe come earlier at like 12:30 if the court is inclined. Or I could do late morning.
Option 2
I have cookies in the
is
car. I'm
not
going to get them. I have to.
press the accelerator all
I've
the
been
way to the
thinking about them.
floor
Bobby just pushed me over.
and not maintain our trial dates and set a less aggressive schedule for the receipt of the second evaluation.
I think that's preferable, and I already talked to Ms. Stapp about a April 27th date for trial.
Yeah, so, right. I think that trying to push this to January 7th is going to prove futile. I guarantee you a defense hired evaluator is not going to have their report done. So,
Let me say this. I am happy to proceed either way. I just wanted to set up for the parties what my thought process was, given what I've heard on behalf of the victims here and their interest in resolving this case, which has been going on for a very long time, and I appreciate that. It was delayed for a number of different reasons, including the absence of the defendants, to honor their interests and try to balance that against what is clearly Mr. Burton's right to seek evaluations for the defendant's competency, especially after there has been such a duration between the last determination of competency and the reports associated with it and where we are today. Again, those were my thoughts about how we could proceed.
Judge, I think the second option is more realistic. In my experience with second evaluators, there's very few that are licensed by the state hospital to do it, and they're all very busy. And sometimes you even have trouble getting one because they say, we're just too busy, we can't do it. I've got one who's willing to do it, but I doubt over the Christmas holiday, he'll get it done within 2 weeks or 3 weeks, wherever. So my preference would be for the second option.
Well, if I may be heard, I am proposing that with respect to scheduling, we leave the jury trial date intact on January 12th. The reason being is this. The district attorney's office has worked tirelessly to get all of these subpoenas issued. We have a number of medical professionals, I think close to 9 medical professionals that would be testifying and have been personally served for this trial. Understanding at this point, we're not going to trial on January 12th. I think the family knows. I will be talking with the family. I have primed them in understanding that we're back in this posture again in this case. And we'll explain to them why we're here and what the potential outcomes will look like. Understanding that, I think it is unrealistic to think that we will be proceeding to trial on January 12th at this point. I would like to keep that date intact so that I can have the court order all my witnesses to a new date. And so I know this is a little bit unorthodox, but I do think in this case, considering the difficulty we have had in securing the witnesses for these repeated trial dates down the line, that we hold a new trial date, which we have talked about April 27th. So the week of April 27th, I believe your clerk said was available. Mr. Burton's available. I'm available. I don't have personal knowledge of all of my witnesses are available at that time, but considering where we're at, I need to kind of secure something so that I can send information to my witnesses for them to appear virtually with the court's permission on the morning of January 12th for their subpoenas to be continued by Your Honor to that next date. That would be my request in an effort to keep these witnesses intact. Some of them are somewhat hostile to this process. So that would be my proposal if the court is open to that.
It's fine by me. I'm happy to, what I would suggest is that we set for trial for 5 days, April 27 through May 1st of 2026. Trial will remain set for January 12, 2026, 8:30 in the morning.
Just for return of
For return on subpoenas, just for 1 day. we won't have it marked off as trial for the balance of that week, but anyone that you've served, Mr. Burton, anyone that you've served, Ms. Sapp,
Okay.
you can have them ordered in, and I'm happy to
Thank you.
have them ordered to the April 27 date. I have no problem with that.
And are you fine with virtual for that as well, for those witnesses?
Whatever you prefer,
I'll be here in person. I think some people may show up in person, so I'll be here to receive them. But for my medical professionals in particular, I would like for them to be able to log on and continue their subpoenas.
works for me. It's your subpoena, and if you feel like their virtual appearance is sufficient for what you're going to ask me to do, I'll leave that up to you.
Yeah, thank you.
Mr. Burton, the 27th of April is good for you?
Yes, it is, Judge. We pre-cleared that with Ms. Sapp.
We'll set this for 5 days, 8 a.m. on the first day, April 27, 2026, 8:30 a.m. every other day. What should we set realistically for receipt of the second evaluation?
What does the statute say? Because
I think it has to be within 35 days.
35 days? Whatever the statute says.
Reasonable opportunity. It doesn't have a time.
It does not have a 35-day deadline.
16, 8.5106, if a
45 days?
defendant wishes to be examined by a
what number
competency evaluator of his
What's
own
that?
choosing, court upon timely motion shall order the competency evaluator chosen by the defendant be given reasonable opportunity.
The information I received from is that in 1H, they asked for it in 45 days.
Forty 2 days is January 29. 49 days is February 5.
February 5 would work.
Ms. Sapp,
I don't take a position on that.
order the second evaluation to be completed in advance of February 5th, 2026. We'll come back for competency status on his competency evaluation on that day. Do you prefer the morning or the afternoon?
What day was it? I'm sorry.
Tuesday, February 5th, 2026.
February 5th.
Morning is fine for the people.
We're going to appear on that date?
Yes.
Okay, right now I'm scheduled for a trial, but it's not going to happen, so I'll accept the date.
That'll be the date, February 5th, 2026 in the morning. What else can we talk about today?
Judge, I have a question.
Yes.
How does it's a while since I've done this. How does the evaluator get the order? Does the court send the order to him or do I?
We issue it and send it to the evaluator.
Okay.
How does that work with the collateral material? Does the DA then send it along?
They would request it from our office.
Request it from you. I'm not involved in the collateral material.
You are not, unless you have access to our discovery.
What else can we talk about today?
I think that's all today. Thank you.
If I didn't say it already, I will vacate the trial days of January 13, 14, 15, and 16. And we will come back together on Monday, January 12, 2026 at 8:30 a.m. Mr. Burton, since there are witnesses who may be appearing virtually, you're welcome to appear virtually if you'd like to.
Okay, I think I'll be in person actually, but,
It's fine.
or both. Because I have yeah.
Either way.
Thank you very much.
Thank you, Mr. Gutierrez.
You're welcome, Your Honor.
What do you mean both?
Mr. Himowitz.
Judge, we can call number 28 Nicole Irons. Actually, this
28 is 19 CR, this is number 28, 19 CR 7732, People versus Nicole Irons.
Sam Himowitz for the people.
and James Gordon McClellan for Miss Irons. She appears to my left.
Good afternoon, Ms. Irons.
Good afternoon.
Thank you for your patience.
No problem.
Mr. Gordon McClellan.
Judge, we do have a proposed resolution here. Miss Irons would be admitting to the violation of her technical terms of probation. Her probation would be revoked as unsuccessful. We have an agreement to no further sanction with the state.
Is that correct?
That is correct, Your Honor.
Ms. Irons, There was a complaint to revoke your probation filed on April 3rd, 2025.
Josh, look at the bottom right-hand corner of the screen.
I understand from your lawyer, you're willing to admit that you violated the technical terms of that probationary period. Start by saying your first and last names.
Nicole Irons?
Are you the defendant charged in this case?
Yes, sir.
Are you thinking clearly today?
Yes, sir.
Are you under the influence of any street drugs or alcohol?
No, sir.
Have you had a chance to review the complaint to revoke your probation filed on April 3rd, 2025 with your attorney?
Yes, sir.
It alleges a number of things, including technical violations. You've missed a number of appointments. Your probation had already been extended once by Judge Shockley. Has the Douglas County matter resolved?
No, Judge, it is not. I think they're close to a resolution, although Ms. Irons, I believe, is intending to take that case to trial.
As I said, the complaint alleges that you failed to miss a number of appointments. I understand that you are willing to admit that you violated the technical terms and conditions of your probation. Before I can let you do that, I need to make sure you understand certain rights that you have. If you did not want to admit, you'd have the right to a hearing, take place in front of a judge, not a jury. At that hearing, the district attorney would have to prove that it is more likely than not that you violated the technical terms and conditions of your probation. You have an agreement here to, upon your admission, that there be no further sanction. I'm going to go along with that deal. Do you understand your
they're
rights
together.
with respect to your probation
Together.
revocation?
I do.
Are you thinking clearly today?
Yes.
Is anyone forcing you or pressuring you into doing this?
No.
I will accept your admission, find it's being made knowingly, intelligently, and voluntarily, revoke your probation on count 3 of the class 1 drug misdemeanor, on resentencing.
Thank you, Your Honor. I did hear the court say that you would be going along with the proposed resolution. I would just thank Your Honor for allowing Ms. Irons, I guess, the opportunity to engage in the potential successful completion, understanding she did some treatment or program. It did not meet the standards that probation had for her. We'd ask the court revoke and terminate unsuccessful with no further sanction.
Mr. McClellan?
Judge, I will keep it brief as well. What I can tell the court is Ms. Irons has suffered a lot of loss and grief in just the last few years of her life. I did receive an email from a therapist this morning. She's been participating in therapy every other week. She's made a lot of progress there. I do think this is appropriate. I would ask the court to waive any outstanding fines and fees as she is represented by our office out of custody. And that's all I have, Judge. Thank you.
Thank you. You don't have to say anything, Ms. Irons. Happy to listen to whatever you'd like to tell me.
I just want to say it's been a long time. I've been in this courtroom for 8 years and you won't see me back here. I promise that. So thank you for the opportunity to just give me that chance because I'm heading in the right direction.
Thank you. Here now for resentencing, I will follow the agreement of the parties, having revoked your probation on count 3. I will terminate your probation as unsuccessful. There's no additional sanction. Any outstanding costs and fees, restitution reduced to civil judgment. The protection order that entered on
Sort of. I mean, it's a big deal that they put her down as unsuccessful. Next time she breaks the law, if she wants probation, they're going to say, well, no, because we tried that once and it didn't work.
October 13, 2019 is vacated. It is no longer in full force and effect, so you do not have to worry about the protection order anymore. What else can we talk about on sentencing?
Nothing from the people.
And nothing from defense. Thank you.
Good luck, Ms. Irons.
Thank you.
Just in case.
All right.
Is Gerardo Sanchez someone who should be here? I don't know if that's a person from 5A. I don't recognize the name.
Don't have any. One part
Wow. Gerardo Sanchez. Before you call the next one, how are our writs and county jail folks?
We have about 4 county jails.
Who do you have?
Judge, this is number 59, Mr. Michael Charus.
59 is 24 CR 7426, People versus Michael Schrews.
Sam Hamowitz for the people.
And James Gordon McClellan for Mr. Shrews. He appears on bond to my right.
Good afternoon, Mr. Shrews.
Your Honor.
Thank you for your patience today.
Not an issue.
Here on revocation, how would you like to proceed?
Judge, I'm just asking to continue for a status. Mr. Shrews has some ongoing medical issues. He wants to get those taken care of before entering an admission. I'm asking to continue to the middle of January. If we could go to January the 15th or the 22nd.
Mr. Himowitz?
No objection. I have seen no pending issues, so people will ask for a more formal update from probation, but that date works.
I saw the December 10, 2025 probation memo. It looked like it only updated the pre-sentence confinement dates or pre-sentence confinement credit.
I think just giving Mr. Shrews a little bit more time, and we can speak directly with probation and then relay that through Mr. Gordon McGlone as well,
How's January 15?
that people can accept that.
That works, Judge. Thank you.
Morning or afternoon?
Afternoon, please, Judge.
Continue your PR bond in this matter, revocation status, Thursday, January 15, 2026, 1:30 p.m. What else?
Nothing further, Judge. Thank you.
Thank you.
Good luck.
Ms. Teeter?
Yes, Your Honor. I'm ready for number 8, Mr. Cooley.
Number 8 is 25 CR 4655, People versus Jalen Cooley.
Sam Hayworth for the people.
And Elizabeth Teeter on behalf of Mr. Cooley, who appears in person while in custody to my left.
Good afternoon, Mr. Cooley. It's today. Ms. Teeter?
Your Honor, the court should be in receipt of paperwork that was filed late this morning. We are planning on entering a plea today.
Does that obviate the need to discuss the detainer filed on November 19?
It is our position that it does.
Yes, sir.
Something in my eye. It's just.
Let's go to bowl cut number 4. Let's get this update.
Allow time to
This
get
isn't it.
through
It's
to see
coming.
his daughter. I told you the last time you were here that in the event she was non-compliant with your custody arrangement, you were not to take matters into your own hands with the repeated 20 to 50 to 150 phone calls that you do. I have proof to the contrary, Mr. Robinson. And if something is happening to where she is busy, that she cannot get a hold of you, how do you know that she's not having a crisis of her own? For you to call 20 times in a matter of a minute or two is harassment.
Thought it through this. Think of situations. Like she could have been busy. Baby could have been sick. That's why she didn't.
Now it's a little bit too late.
Or she doesn't want to talk to you.
Myself instead of.
Ma'am, he goes with you. Bye-bye, Mr. Robinson. You didn't get it last time. Yeah. See if it happens this time. Let me figure it out. Ma'am, stay away from me. Don't set him down, please. I'll take care of this one, Judge, and then I'll come back. I'm gonna scare her. You wanna let her think about it? Give me 30 minutes. You got it. I'll be back in
Look, 20, 30 minutes.
Ogletree, Mr. Ogletree, yes. Yes, he is. All right, good morning, Mr. Ogletree. Sir, you're charged with burglary of a motor vehicle. You're facing up to a year in jail and or a $4,000 fine. What are we doing today?
Your Honor, there's an evade, he's also charged with an evading, he's taking a plea on evading, they're dismissing the burglary of the motor
Is
vehicle.
this what you want to do, sir?
Yes, sir.
What you must understand, Mr. Ogletree, is that you are entering into a lifetime decision right now where, are we doing time served or what?
I'm sorry, yes, sir.
This charge will go on your record. But what you must really understand is that this is an enhanceable offense, meaning that this evading will go on your rest. It's going to be there for the rest of your life. It's even there after you die. You ever run from the cops again, you will be facing a felony charge. Instead of days down here, you're going upstairs where it's years. You understand? No matter how trivial it is, years. You understand? Not only that, if you pick up a misdemeanor from now on, you'll be facing a minimum of 90 days in jail. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this, you can never come back and change this. One more thing, Mr. Ogletree, you live in Texas. Not 3 weeks ago, someone died from a BMV where they were trying to protect their own property and they shot the person in the car trying to break in. I would be very careful who you mess with because the next time you may have a couple bullet holes in you. Good luck. Thanks. Hey, yeah. Say it again.
113 days.
Yeah. 113 days. Wow. Did he have a felony case? No.
This was flooded in.
Oh, yeah.
I said, I always say something. I always- I said
That's why I was wondering. So, what are we doing?
This is the case.
113.
I didn't realize it rained that bad. I mean,
Oh, I bet the felony's being dismissed. Then. That's
there's-
what's
I
going
think
on.
it's-
Okay. Hey, Mr. Stryker. Hey. Sweat.
Mr. Sweat, planning to report today, but he was flooded. I've
220 days. Today
been
was,
on the case, I was appointed on February, but again, you know,
today was clear trial.
just later this week, he just flooded.
Okay.
He just, you know, I talked to him yesterday, he was intending to be here this morning, he just said, hey, I can't.
Okay. Up to Wednesday, because
Absolutely.
don't be mad. I'm gonna be gone Thursday and Friday.
DWI case?
Sorry. I know. Hey. Hi, Wes.
Plea, Miguel Rodriguez.
Ready?
Yeah.
Okay. You mind bringing him up?
Is that Pavel? Is that Pavel coming up? Hi, Pavel.
Yeah. It's gonna be 5-1. When's the first one?
89. Good morning, Mr. Rodriguez. Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 180 days in jail to be probated for 13 months. As part of that, you will do a DWI education class, a repeat offender DWI education class. 2 victim impact panels. TRAS with conditions, meaning that if they assess more conditions, you must fulfill those conditions. Guardian interlock, no drugs, alcohol, random urinalysis, and no breath test refusal. That means that if you were pulled over and an officer asks you to submit to a breath test, you must submit to a sample. You now have 2 on your record. Do you know what happens if you pick up another one?
Sir.
And then what?
Done deal. Let's,
It's no, but it's never. Not until you die is it a done deal. You know, no matter what you drink, no matter how faint the smell is, they're going to see DWI, DWI. If you get pulled over, even the mere smell of alcohol, they're going to charge you. And next time you'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. I would never, even if you've had a sip, would never take the chance and get in a car because it's going to cost you so much. How much money have you paid Wes when a $20 Uber call take you anywhere you want to go? I'm also going to suspend your license for 1 year, sir. It's a second offense, so you're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand? How do you plead to the offense? I will find you guilty. I will follow the agreement. I'm serious. I would never, even if you had a sip, get in a car. You can be facing a lot of time.
Yes, sir.
Good luck to you, sir.
Thank you, Your Honor.
Now, every father should have the right to have access to their kid, but you can't do what you're doing. I mean, that's just not cool. That's not cool. Now, if she is truly withholding, you have to find the right avenue to do it. Calling 100 times is not it. Tell me while we're waiting.
He went and tested negative for everything.
Wonderful.
And
Great.
he
Good
is-
job.
Yeah.
Keep it up.
Um,
Or just, I guess, have him wait right here and then I'll talk. I will never play this game with you again. If you and I see each other again, I'm assuring you a very lengthy jail sentence. No means no. Doesn't mean maybe. Doesn't mean she's got my kids. There are proper ways to fight someone who doesn't want to give you access to a child. Calling 30 times, 50 times is not the way to do it. We are going to try to formulate a plan to help you, Mr. Robinson. Until we have done that, I don't want you to have
idea.
any contact with her whatsoever.
No. Tell her she won the lottery. Tell her she's about to get arrested. Tell her her social security number has been exposed. That's clickbait. That'll make her open. Victoria, you won the lottery for $1 million. All you have to do is open this email. She'll open it right away, I'm sure of it.
However,
Then
do you
just say,
understand?
just kidding.
What we're going to do is we are going to postpone your case until Wednesday.
Thursday, Judge.
I'm gone Thursday. I'm not going to be here.
Friday?
I'm not here Friday either. I'm gone. I'll be with a bunch of 12, 13-year-olds in San Antonio.
Will you come back next week, next Monday? I'm just trying to, because I'll.
I'm okay with that as long as he realizes that you cannot have contact with this person until Monday.
Next week.
I'm okay with that, but
Then we-
no contact means no contact, Mr. Robinson.
That's the 6th, May 6th. That's when.
I will do
Monday, yeah,
whatever.
Monday's good. I'm off on Monday.
Then Monday it is. But this is what we're going to do. I want you to come back Monday. I want you to bring me a copy of your custody and visitation order. I want to see what the judge set forth as you being able to have access to the child. We will set a plan in place because our probation officer has the ability to contact Michaela. We will try to set forth a plan so that you can have access to the child without you having to call as many times as you have been. All you're doing is you're alienating her even more, where she's going to restrict further access. You're going about things the wrong way. Do you think someone wants to have them contact 50 times? Right. Do you think that's going to have them resent you more? Yes. So we're going to try to create something for you. On Monday, when you come back, bring me a copy of the order. We'll see what the judge said as far as time is concerned.
I'm just saying, if more sentences would start with, Kathy says, this world would run a lot smoother, a lot.
We will also reach out through the probation officer to her to make sure that she knows this is the proper time. He will only be able to call you at this time so that there are no issues. And if then she continues to restrict your access,
Monica,
somehow we will
thanks
help
for
you get to the family
cheers.
court so that you can have her held in contempt for willfully withholding and violating the court order she's got and you have. Do you understand? If at that point she still is giving you, if she's not giving you access, you go to the family court and they will hold her in contempt. Okay.
Thank you, Judge.
No contact until we get something set up. Okay, all right. You can, please. You can let him go.
Thank you, Judge.
Thanks, Mr. Duong.
Yes.
So there's no, so I know it's filed. I'm just going to keep it there for the time being. In the event something happens, because I can still issue the warrant. Let's postpone this to Monday. Would you mind reaching out to the probation officer to let her know that we're going to powwow on Monday? Reach out to the young lady to let her know. And let her know, also know that if she starts playing games with us, it's really going to go bad her as well. Okay, ready? Mr. Pena, come on up.
Bowl cut number 4.
You're back into school. Good job. And I'm proud of you that you tested negative. That's great. Keep it up. That's all we're asking. Don't test negative again. Otherwise, it's really going to go sideways. Do we have an offer on this case? Do you have?
It's a UCW with POM. We don't have labs yet, so we're just waiting on that before they're gonna give an offer.
So you're not prepared to make an offer, I guess?
No, I made an offer. I think the lack of preparation is just for the sake of this bar card.
Yeah. I understand, but
I made the offer.
got it. Okay. We'll give you normal reset behavior zone. You're doing great so far.
And
Okay.
as of right now, his bond conditions already come back every week to be drug tested. Now that he is in school,
Are you actually going physically to school? Are you doing online? How are you doing virtually? How are you doing school?
Davis High School.
Great. Are you going every day?
Yeah, I'm gonna start going every day.
next week, Judge.
Next week I start.
What day do you start?
Probably Monday because on Wednesday I have an interview, so they could give me my schedule.
School is more important than work. You need to graduate.
School interview, Judge.
Oh, school interview. Okay,
School
good,
interview.
good. Okay, great. Finish high school. Otherwise, your life's gonna suck for the next 40 years. No more dope. So let's set it off a couple weeks, and then we'll come back in a couple weeks. I'm gonna drug test you again, so you know. You're negative now. Don't test positive. All right?
Do you know when school ends this semester?
I'm not sure.
Okay.
I mean, we're close to ending school anyways. I mean, I think we're in the last 6 weeks of school as it is, so
I'll get with him on the schedule. We'll work.
yeah. Yeah.
Thanks, Judge.
Okay, thanks. Anthony Ago? Mr. Ago, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
This is on.
A go. Yeah, it's an unlawful carry.
Mr. Cousin? Yeah. Judge, this isn't screened yet, but I'll read it per the sworn statement. Officers Vela and Baumgartner, on April 28, 2024, at approximately 3:09 hours, the defendant was identified by his driver's license. Conducted a proactive patrol investigation in the district in a marked HPD vehicle, observed a black 2012 Ford Mustang bearing a license plate KXM 1690, driving southbound at approximately the 3300 block of Ashlock Drive in Harris County, Texas. Officer ran the license plate through MDT and found the vehicle to have registration expired as of August 22. Officers initiated a traffic stop at approximately 3:09. Vehicle stopped. They exited the patrol vehicle, explained the reason for the stop to the driver. While asking for the driver's license, the officer observed a black Canic handgun in plain view, not in a holster, resting on the passenger seat floorboard, leaning against the center console within the wingspan of the defendant, who was the sole occupant of the vehicle. Defendant was asked to step out of the car. He complied. The defendant was outside. Officer's partner observed plastic packaging and small amount of green leafy residue consistent with marijuana. Defendant had a moderate odor of marijuana coming from his person. So officer asked the defendant if there were any drugs in the car, to which the defendant replied that he had smoked earlier. There was nothing in the car. Officer recovered the handgun from the floor of the vehicle and secured it in the patrol vehicle. The handgun was purchased legally and was registered to the owner. They have the defendant detained by placing him in the handcuffs in the back of the patrol vehicle. Searched the vehicle for other contraband and narcotics. Due to safety concerns. Okay, so officer submitted the marijuana residue contained in one plastic baggie for a total weight of 3.9 grams. The defendant was identified by his driver's license and they accepted the charges.
Got it. Okay, so sir, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license, sir? Do you have valid liability insurance in your name?
No, not at the moment.
Then you're not allowed to drive. I'm going to make that a part of your bond conditions. If you drove here, you may not drive home. You do not have liability insurance. Okay, well, I'm telling you that you can't drive, and I'm going to have you sign with me today. I promise that you're not to drive until you come and get court approval and prove to us that you have liability insurance in your name. You're not to drive. Understand? If you do, you'll be facing a contempt hearing, 6 months of jail, and a $500 fine every time you drive. I'm also ordering you as a condition of your bond not to be in possession of any weapons. If you violate these conditions, you will go to jail. You will not get any more PR bonds. Do you understand, sir? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Victoria where you're going to sign and reset, and then we'll get you out of here. And when you come back, please have a lawyer, sir. All right, come up here. We'll have you sign this. Then I'll get you to Victoria. And then I'm going to have you take a seat in the jury box while we get your bond conditions, and then you'll be able to leave. Do you mind filing no weapons, please? I have to imagine it's a high bond. Joseph.
Yes, yes, Judge.
Hey, bud.
Hi, sir.
Torres Reyes,
Yes, sir.
you're still missing some stuff.
What are we missing? I thought last item we needed was the DA fee, which you got.
Let me take a look. This is on press.
Torres Reyes. Cesar Torres Reyes.
You need to add an address on the top of page 2 of the contract and a proof of the portable device. We don't have it filled out, proof of portable device.
He thought he was gonna have some time to get the device.
His last name is like the
What was that, Council?
Can you hear me, Pablo?
Yeah.
He said he thought he was gonna have some time to get portable.
Hey, give me.
No, we need proof of the portable device before we can file the order.
Okay. There's a form in that contract for the device, I believe, correct?
Yeah, that form needs to be filled out as proof of the portable, and that way we can file it, the supervision order.
Do you have the portable device?
No.
Come up.
No.
You were supposed to have the portable device today. Your case is 220 days old. What is going on?
I didn't know I was supposed to have it already.
Hey,
I would have had that information if I gotten it.
Judge, can I step in and kind of fall on the sword for him? 'Cause he's not playing. We got the contract over the weekend. I'm just, I wasn't able to get it printed out. So I told him that he could just, he needs to get that as soon as possible. He's not driving. He did a no driving affidavit, but he needs to get a license.
I will set you off for a week. You have 1 week to get the portable device.
Pablo, can you please tell me what else? It's hard to hear over the Zoom. Can you please tell me what else, or email me what you're missing so we can get this thing finally resolved?
So I just need the proof of the portable device, and on the top of page 2 of the contract, I need an address.
Oh, okay.
Yeah, that's it.
Well, he can fill that in right now.
Yeah.
Okay. Did you hear that, Caesar?
Yes.
You left blank your full address, and then get the portable device, and we'll be ready. Okay.
You will not get another, if you don't have it done in a week, you'll get set for trial. I'm not giving you any more resets after the week. So you must get with your lawyer today to figure out. I want you to call today to make the appointment,
Yes, I understand.
please.
Thank you, Ron.
Okay. All right, fine. It's just.
I didn't want to do anything extra.
I like to move it.
In case he come back. No.
Now we all can sing that song for the rest of the day or night. I like to move it, move it. Thanks, Judge, for ending on a good note. Thank you. Okay, now we're going into 2 different hearings, all right? And we don't really need the second hearing. Hi, big booty starfish. See you sneak in. There's 2 hearings, but it's the first one that we want. But the first one bleeds into the second one. And since you've already invested so many minutes of the second one, I thought I would just put it in here so you could see it, because you've already invested time in it. You'll see what I mean. Here we go. We're going to Colorado. Eric
CR
Johnson.
259,
Judge
People
Eric
versus
Johnson.
King, entries.
Bradley Sherman for the people.
Meredith Dickerson on behalf of Ms. King, who appears on bond.
All right, we ready to proceed to sentencing?
Yes, Your Honor.
Defense is ready.
Are any additions or corrections to the April 17th, 2024 PSI?
Nothing from the defense.
Nothing from the people.
All right, go ahead, prosecution.
Thank you, Your Honor. First, did Your Honor have a chance to look at the exhibits I dropped off?
Yes.
Thank you. So, I mean, based on just those 3 exhibits, I think the court gets a pretty good idea of how aggravated and violent this case was. I know there was some debate about whether or not a gun was used, whether or not a rock was used, but clearly a deadly weapon was used. And with that deadly weapon, Ms. King hit the victim, Kimberly Velez, in the head with it, while Ms. Velez was with her child. Her child was in a stroller when this all happened. The defendant could have killed the victim in this case over an Xbox and some insults over text. Your Honor, this was not off an impulse. The defendant made a choice to drive over to the victim's apartment to obtain a weapon, to walk up to the victim's apartment, knock on the door, and then hit her in the head with a deadly weapon. This event has completely changed the victim's life. She has a statement that I'm going to read in just a moment. But before I do, I just want to note a couple things. So this took place on January 1st, 2023. As the court is aware from the 404B motion in this case, just a few months before this, the defendant did something very similar. She went over to someone's apartment and she hit a woman in the head with a baseball bat. Your Honor, the people do not believe that probation is appropriate in this case, and that's why we're asking for DOC. As you can see in the PSI, the defendant has been on probation 5 times. She's only been successful 3 of those times, and she's committed new law violations while on probation. It's clear that she's been given multiple chances, but here we are yet again. She's committed another violent crime. Your Honor, I had Ms. King's misdemeanor assault case, so I'm very familiar with the personal circumstances that she's facing in her life, the difficulties that she faces. I understand that she has several children, some of whom require a lot of assistance. And I can't imagine being in her position, but I don't think her personal difficulties outweigh our community safety concerns. And I also don't think they outweigh the impact that this has had on Ms. Velez. And at this time, Your Honor, I would like to read Ms. Velez's statement. She is present in the courtroom, but she's too nervous, understandably, to speak. So she says, Your Honor, this assault that happened to me has ruined my life. I can't remember a lot of the time, and I have to go to the hospital tomorrow due to swelling to the left side of my brain. I have nightmares about this, and me and my little girl suffer from PTSD. I can't work and possibly have to deal with this for the rest of my life. I suffer from a traumatic brain injury, PTSD, and memory loss. Because of King, I cannot work for the rest of my life, and I have to go to counseling with my daughter. I didn't deserve this, and neither did my little girl. I'm very emotional about this. I can't talk about this without breaking down. It's been a struggle since this happened to me. She, the defendant, did not need to do this to me, especially in front of my baby. I wish this never happened to me. Now I have to go for surgery on the left side of my head here in a few weeks, and I'm scared. And I would also add, Your Honor, that the victim, Ms. Velez, is also asking for DOC to be imposed. Beyond that, I have nothing to add, Your Honor.
Counsel?
I will note that I filed a sentencing memorandum today, actually this afternoon. I apologize. There was a lot of my caseload set on this Monday. Has the court had the opportunity to review that? And I can also summarize most of it in my argument.
No, it's 6 pages, and I had made it through everything that you had typed. Well, I mean, technically it's 5 pages. It bleeds over. The only thing I didn't get a chance to do was read the Coalition of the Homeless letter.
And I can give the court some time. If the court would like at the end, I can go ahead and jump into my argument.
Yeah.
So I would first note that Ms. King is in a interesting posture for a defendant who is on bond for this case and facing sentencing open to the court. She has not been on able to be on bond the entire time that this case has been pending, she has spent most of it in custody on that 22N 5013 case. The reason I bring this up is because Ms. King is not sitting here asking for probation as somebody who has been out in the community pending her trial the entire time. She is someone asking for probation who knows the real tangible implications of a possible revocation of her probation, which is incarceration. She has spent she has spent 7 months and 20 days up until the end of January of this year in custody, away from her family, missing birthdays, holidays, and also dealing with a really scary medical situation that put a lot of her own life into perspective for her. This is the longest that she has ever been in custody, and it was also 7 months and 20 days that she was not on the recommended prescribed injection for her medical condition that she has been on since being released from custody. It was very dangerous for Ms. King to be on a different regimen given her diagnoses. And it was also a struggle for her to be on different medication in the jail. If this court does impose community corrections or DOC or anything related, we are not sure that she could get the adequate medical care for her medical condition, and she could risk her health declining, again, just because an institution doesn't have the exact injection that the modern medicine has made, unfortunately, both very easy and very expensive out of insurance. So I just wanted to bring up the dangers that she is facing if she does go back into incarceration for this court. An incident happened a couple of days after she was released from jail where Ms. King was experiencing mania and paranoia and voices in her head. Her mental health has, in the past, sparked kind of a cycle where a crisis will occur and violent behavior will follow. And essentially, Ms. King did, a couple of days after she was in custody, choose to go to Peakview Behavioral Health Care instead of following that cycle of a mental health crisis, aggressive behavior, and then what usually followed were charges. Ms. King has been addressing her mental health issues, thank you, with several different medication management systems. So first, she is in the Colorado Coalition for the Homeless Stout Street Collaborative, where she is getting medication for her diagnoses of bipolar and post-traumatic stress disorder. And additionally, she is managing her serious medical condition through empowerment. Through both of those organizations, she does behavioral therapy. She has been continuing behavioral therapy. That was something that she did while in jail. And she has people in her life who can attest to how well she is doing at this stage. And I will read the letter from her psychotherapist as well as from her empowerment case manager in a moment. With the event that occurred in January 2023, I will note in the PSI that Ms. King is incredibly, incredibly remorseful for what she did. As I noted in the sentencing memorandum, Ms. King unfortunately did find out during that time that her youngest son, who was a nonverbal autistic kiddo, was being sexually abused by her soon-to-be ex-husband, Jermaine Griffin. Ms. King was incredibly triggered by this since she herself had suffered from substantial abuse, both physical and sexual, when she was a young girl. And she essentially spiraled into one of those mental health crises that we referenced earlier. She is incredibly remorseful in the PSI, and she is as she stands here today, but I'll also note that in the PSI, when speaking about this incident, she did give further detail that was actually contested by the evidence, just showing that she was willing to be incredibly candid and open with the court. I want to read some information from her case managers, but I also want to go into her past performance on probation. So if the court will just give me a moment.
She
So,
does talk a lot, but it's worth it. It's coming.
Mr. Sherman and I disagree that Ms. King has had several opportunities while on probation to prove herself. So the first time that she was put on probation was in 1999 when she was a minor. She was a juvenile, and she was regranted probation. So I believe that this constituted 2 of the 3 times that she was put on probation. A note from that case, when her probation was officially revoked for a last time, states that community-based options have been exhausted. The juvenile is rapidly approaching 18 years of age and is in need of services immediately and effectively. During this time, Ms. King was a homeless youth. This was her first opportunity trying to navigate probation while she was in a very different place in her life, a minor and experiencing homelessness. And I just thought it was interesting that the court chose to include that she was in need of services immediately and effectively in that minute. When they did revoke her probation, they still noted that she was struggling and at very high risk. And then in 2003, that is when Ms. King received probation for a second time, and that is her only felony conviction. And she did complete probation successfully. And this was despite being homeless and having to complete 75 hours of community service as well as anger management classes. The court gave her extra time, given her homelessness, to complete those things, and she did complete them. She completed probation in 2017 in Joplin, Missouri for a shoplifting case. And her most recent time she was granted probation was in 2020. Where she was switched from supervised to unsupervised probation on April 26, 2021, and then terminated. So her history of being on supervision definitely shows that Ms. King is willing to fight through obstacles in order to complete her sentences successfully. She has young kiddos at home. She has been taking care of them and is the sole caretaker of her 2 sons with autism. She is hoping to stay out of custody and in the community in order to make amends for what she has done, address and continue to address her mental health issues and substance use issues. And then I will just note for the court before I read her letters of support that Ms. King's daughter is here. I see that the sheriffs have been called in, and I just wanted to note that if Ms. King is not granted probation, or if she is granted any jail time with probation, we would ask for a 30-day stay of execution on that remand date. Ms. King has been working diligently to prepare her children. She knew that she was going to sentencing today. The only hang up is that her nonverbal 5-year-old has to have a special caretaker that she has not found yet. And so she's asking if she does go into custody today for a few more weeks to be able to find care for that son. The first letter of support is from Dominique Archibek, who is her case manager through the Empowerment Program, who both works with her mental health issues, but also with her medical condition that I referenced in the memorandum. And it says, to whom it may concern, Devetta Griffin is a participant in the Empowerment Program under case management. She has been engaged with services at Empowerment for quite some time. Her main goal is to become empowered to maintain stability for herself and her children. Since she has been released and completed the RISE program within the jail, she has maintained a one-on-one with case management and a one-on-one with mental health therapist Roxy Davis. She's attended psychosocial events with other participants, engaged in the community, and she has maintained her most important appointments, which are her health and medical appointments.
Okay, I have to pause real quick because of what she just said. She completed the RISE program in the jail. Okay, so all these jails in all these cities that we watch, they have these their own special programs for inmates, and it's always the same thing, like 4% success rate or, 20% success rate or whatever. Not this RISE program. This RISE program has like a real high success rate. So when a judge hears they completed the RISE program, that actually does mean something to them, because it does have a very high success rate. It doesn't matter. She hit someone. She bludgeoned someone in front of her daughter. I mean, so RISE program or not, that's what she did. But it gets worse. Wait until the judge talks. But now you know, the RISE program, she said those magic words, so.
She has also been able to maintain medication adherence, which is a big part of the stability of living a healthy and productive life. I, as her case manager, have been starting to set goals for employment, education, and continuous support. I see Ms. Griffin driven for success, not only for herself, but for her kids. I cannot express enough what her kids mean to her. They are why, and they are the reason that she keeps fighting and moving forward. Ms. Griffin will maintain case management, attending groups and attending mental health meetings, and she will also maintain her medical adherence to be in the program, as she has. She will continue to work with myself and other staff to help her, to guide her to be successful. And then she includes her contact information if any further questions are asked. And then I can read the letter from the Coalition for the Homeless. That's from her psychotherapist, James Milton. Says, to whom it may concern, Devetta Griffin has been my client in psychotherapy since her first appointment in February of 2024. She has worked with me previously since 2021. Her current diagnoses are bipolar disorder type 1 and post-traumatic stress disorder. Ms. Griffin also works with Josephine Sullivan, a psychiatric nurse practitioner, for medication management. At this time, Ms. Griffin has attended 6 therapy sessions with me and 2 with Ms. Sullivan. Ms. Sullivan has prescribed the following medications for Ms. Griffin: Abilify, Wellbutrin, naltrexone, all of which are prescribed to be taken daily. After discussing her current legal challenges, I have challenged Ms. Griffin to advocate for herself regarding the reasons why she should not be sentenced to any additional jail time. We were able to come up with several convincing reasons why whatever sentence she should receive should not include jail. Ms. Griffin has 4 children living with her at this time. 3 are minors, including 2 young boys with special needs. If Ms. Griffin were to go to jail, her children's mental and physical well-being would be compromised significantly. Ms. Griffin has shared with me that she has already served an 8-month jail sentence, and she believes that this has been a sufficient punishment and that she's made significant changes in her attitude and beliefs. She's ready to follow the rules set forth by the court and remain compliant with treatment. Furthermore, she has committed to maintaining abstinence from all illicit or intoxicating substances. In addition to her mental health disorders, Ms. Griffin has chronic physical health issues, both of which would be negatively impacted by being sentenced to a jail term. Ms. Griffin contends that she is on a positive trajectory with her health, family, spirituality, and at this time remains committed to continued progress in all areas of her life. A jail sentence would be a significant setback for her. And then I also have Ms. King's daughter here who may want to make a statement. This is Jalecia Love.
This part is a little hard.
Hi, Judge Johnson. I'm Love. My mother,
To start off real fast, just let me know what your name is, please.
Love, L-U-V,
Full name?
Jalecia Love.
Thank you.
I'm making a statement for my mom. I understand what she did. I understand that what she did may require consequences, but I'm asking you, please take into consideration me and my siblings. If my mom were to go to jail, then it would just be me. And we just got her back not even fully 3 months ago. I understand what she did was wrong, I really do, but I understand that her actions need consequences, I do, but I feel like her being gone for that long was already consequence enough. She's really changed completely from her being incarcerated last year and her being out and her coming out this year, she's a completely different person. And I'm asking that you take into consideration probation because we have no family. It's just me and taking care of two autistic children. And I just started going back to school and it's a lot. It's a lot of stuff and I don't know what I would do without my mom. I didn't even know what to do when she first went to jail because she's been here the whole time. That was the longest I've ever been apart from her. I'm please asking if you can take probation into consideration. Thank you.
Thank you, ma'am.
And I just want to clarify, before I let Ms. King make her statement, that the defense is not asking for this court to accept her punishment from the 22M case as the punishment for this case. We are asking for a separate term of probation, which is punishment in and of itself, for however long the court would deem appropriate in this case. And we had even talked about the potential of this court suspending a jail or a prison sentence. We are asking for separate punishment. We are just asking the court to consider the severity of the 22M punishment and how that has impacted and will impact her perspective in taking advantage of probation in the future.
Can you have the right to tell me anything you'd like me to know before I sentence?
I'm writing you today to express my sincere remorse for my actions that has brought me here. I know that I have made mistakes and I am truly remorseful for the pain and suffering that I have caused the victim and my family and her family as well. I want to assure you that I am a good person and a good mother. I love my children more than anything in this world, and I would do anything for them. I have always tried to be a good role model for them, and I have taught them the importance of honesty and respect. I know that I have not always lived up to my own standards, but I am committed to turning my life around. I have been attending counseling and attending classes voluntarily. I am working to address my issues that led me here. I'm asking for your leniency in this case, and I know I have to be held accountable for my actions, but I am confident that I can be a productive member of society if given a chance to right my own wrongs. I promise you'll never see me again.
You know, these sentencings are always really hard. And you said you're a good person. I'm not here judging you as a human being. Not my job. I judge what you did, on January 1st, 2023. When for no reason you knocked at a woman's door, she answered the door and you bludgeoned her. I hear you. The reason you did that much jail time on the other case is because you took a baseball bat to someone else's head. And before that, I couldn't get to the facts in the case, but you menaced somebody with a deadly weapon. And that was bad enough that even in 2003, they sentenced you to 90 days in jail. And after that, there's a third-degree assault out of Arapahoe County. That was a stabbing. You stabbed somebody. And they pleaded it down to a misdemeanor. And then you had another third-degree assault, the 22M one, the baseball bat issue. I mean, you asked me to think about your kids. What about you? Thinking about your kids. You'll do anything for your kids? How about stay on your meds? How about not? How about, the first time you stabbed somebody, or the second time you assaulted somebody, or the third time you assaulted somebody, not, doing anger management and things like that. How about doing that for your kids? Because now what you're asking me to do, and look, I care about your family, and I care about your daughter, but for goodness sakes, you put a woman in the hospital for nothing. That's just not a probation situation. It just isn't. If somebody had come up and beaten your daughter, you know you would be in here, Mama Bear, telling me to put her in prison. You know you would be. Here's what I'm going to do. And I do not want Ms. Velez, I don't want you to think that, I know how serious this is. But trying to look at the big picture. I acknowledge what Ms. King has done. And maybe that 7 months in jail was what it took for you to have an epiphany. That does not excuse what you did to Ms. Velez. And so you're not walking out the back door. But my notes on this case were just 3 years prison. I'm going to give you some benefit of the doubt that you have made changes. So I'm going to give you 3 years in ComCorp. Why? Because look, Ms. Velez, community corrections is a punishment, absolutely. It may not sound as good as, prison, but it's a hell of a punishment. And society is going to be better off if Ms. King quits assaulting people. And either she has turned a corner or she hasn't. You walk away from ComCorp, we just call it a change of address. We just convert it to DOC. You pick up another case, this automatically converts to prison. You violate their rules, this automatically turns to prison. And it's the 3 years. So I'm going to give you some benefit, or I'm going to give some credibility that maybe. I don't know if I believe it or not, but I want to believe it. I want to believe that you've changed, and I want to believe that you're going to stop beating people. So rather than just straight prison, I'm going to give you ComCorp, but you don't get to remand later. You're going to be taken into custody today. You're going to spend your time in jail today, and then you're going to, when a bed opens up, you're going to get into community corrections. Oh, and her baby watched her get beat down. I know you're sorry. Everyone's sorry when they get caught. Everyone's sorry when they're getting punished. Your kids tell you they're sorry when they're getting punished. I understand that, but there's no way that this is a walk out the back door type of crime. You're getting a massive break with the 3 years of community corrections.
Oh, God.
I'll note the 170 days of credit.
Oh, God.
We'll reserve restitution for 49 days.
And the credit that I calculated was 236.
Oh, God.
And if the people object to 236, then you can file a motion with the court.
Yes, Your Honor.
Oh, okay. Oh, God.
What's that?
170 credit or 236?
The 236.
How long do I have to object, Your Honor?
You do get locked up for community corrections. You get locked up, and then you work your way into like being out of jail. So you go to community corrections, you're in a cell, and then you go to your classes, your drug classes, your anger management, whatever. And if you do well with them, then you can get like a weekend out or whatever. And then you find a job. You're still locked up, but you find a job, and then they help you find a house or apartment. I mean, a room. Not even an apartment, a room. And then you get to get out of jail like 2 days a week and go to your room and go to work, and then 3 days. So it's like you work your way up out of jail in community corrections.
2 weeks.
Thank you.
Can you give it to my daughter? Yeah. Oh, God. Oh, can I please get my daughter? And please. Oh, oh, God. Oh, I love you, baby. Oh, God. Oh, God. Oh, God. Oh, God. My Albert. Oh, God. Oh, God. Oh, okay, please, let me just see. I need you. Oh, God. Again. No. Oh, God. Please. Don't take me now. You said what? It's okay. And you walk in and fight. I'm asking you, Your Honor, please. Oh, my God.
Do not talk to the judge, ma'am.
Oh, oh, yeah. Oh, God. I just left here. I know. I just left here. Please. I just left here. I just left here. I just left here.
Mr. Black, who are you calling next?
Mr. Cooper.
Number 70.
No, Mr. Cooper, not today. We did it. We made it to the end. Thank you for staying awake. All right, guys. I'm going to get OJ going. And I shall see some of you there, and I shall see the rest of you tomorrow. I hope you guys have a great day. Thank you so much for coming out. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her style see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see